English shorthand 150 words per minute. Legal passages. Book code LPB-2 of National Shorthand School, Vizag. Legal passage number 28. Please get ready. Start. In view of the above details of the case, the following would emerge for consideration. 1. Whether fresh lease deed has been executed by the lessor Dr. Manjula in favor of the lessee Messrs. Raja Info Limited. If so, to what period? 2. Whether the lease agreement is required to be registered under the provisions of the Indian Registration Act 1908. 3. Whether the correction of the flat number 608 in the true copy of the will is genuine and correct one, or clause 7 of the will flat number 606 has only been mentioned. 4. Whether the will dated 1910-2004 executed by Dr. Manjula in favor of Dr. Baldev can be treated as will executed by Dr. Manjula. In other words, whether this document can be treated as a valid will. 5. Whether the general power of attorney is required to be registered in view of existence of clause 4 and 5. With regard to item number 1 above, it is advised that Messrs. Raja Info Limited may verify from their records whether a fresh lease agreement has been executed between the parties. With regard to point number 2 above, it is to state that in terms of section 17(1)(b) of the Indian Registration Act 1908, other non-testamentary instruments which purport or operate to create, declare, assign, limit or extinguish, whether in present or in future, any right, title or interest, whether vested or contingent of the value of 100 rupees and upwards to or in immovable property are required to be compulsorily registered. The words used in this subsection are non-testamentary, and the said words are used to refer those documents which are intended to be operative with immediate effect and to be final and irrevocable. The clause B of section 17(1) of Indian Registration Act 1908 provides that all non-testamentary instruments other than those of gifts must be registered if they purport or operate to create, declare, assign, limit or extinguish, whether in present or in future, any right, title or interest, whether vested or contingent to or in immovable property of the value of 100 rupees and upwards. In this connection, it is stated that in this case the document referred to is lease, and hence it is stated that the word lease be used in the same sense as defined in section 105 of the Transfer of Property Act, and it may be noted that the lease of immovable property from year to year or for any time exceeding 1 year be compulsorily registerable, whatever may be in the value of interest created thereby. In this case, in the initial period or lease is for 3 years, extendable for another period of 3 years. The lease agreement executed initially on 11/8/1996 be compulsorily registerable document. So it is necessary to verify whether the lease agreement be registered or not. It may also be verified whether the lease agreement has been registered or not. With regard to point number 3 above, it is stated that Dr. Manjula is only having 50% share in flat number 608, but by the will, the figures 606 has been corrected as 608. So it may be verified whether Dr. Manjula has executed will in respect of flat number 606 or 608. With regard to point number 4 above, it is stated that in the copy of the will, it has been mentioned as do hereby revokes the former wills and codicils, if any, made by me at any time hereto, and make and declare that this is my last will and testament. The fundamental idea of execution of a will is that the testator should dispose of his property or such part thereof as his personal law permits him to bequeath by a will in such manner as seems to him best. A will is an expressed intention as to what should happen to the property on the death of the testator. A will, though executed by a living person, takes effect only on his death. It should have the characteristics, namely, it must be intended to come into effect after the death of the testator, and it must be revocable. If a person executes a document coining it as a will, only indicates that he bequeathed his immovable property to his heir in absolute right, and that is his last will and testament, as the said document has not mentioned that the direction given by him should come into force after the death, or that he is reserving his right to revoke the document at any time before his death. The said document cannot be termed as a will. The rulings of various courts make the position clear that unless a document satisfies the two characteristics, that is, it must be intended to come into effect after the death of the testator, and it must be revocable, it cannot be treated as a will. A document cannot be treated as a will by a mere reading of the heading of the document. In that view of the matter, after going through the contents of the document said to have been executed as a will by Dr. Manjula, as the said two characteristics are not existing in the said document, it cannot be treated as a will.